Good morning, Your Honors. Andrew Crouch for the juvenile, Ronald R. May it please the Court. The juvenile appeals today from a decision by a judge in the Brockton Juvenile Court not to relieve him from the obligation to register as a sex offender pursuant to a proceeding that took place pursuant to General Law, Chapter 6, Section 178E, subsection F. The first issue I'd like to address is the juvenile's right of appeal from that judge's decision. At the outset, I'd like to note that at the appeals court level, the Commonwealth initially argued that the juvenile was not entitled to this relief from registration hearing. That argument, it's my understanding after consultation with the registry board, has not been pressed here. So for purposes of this hearing, we would rely on the brief for the argument that the juvenile, in distinguishing between juvenile delinquency findings and convictions, is entitled to such a hearing under Section 178E, subsection F. Here, the required hearing under subsection F was a necessary extension of the juvenile delinquency process. This was a situation that was not one that was indeterminate or not required. Subsection F requires a judge, a trial judge, within 14 days of sentencing to make this determination as to whether or not an individual should be relieved from the obligation to register as a sex offender.
Okay, if we agreed with you that the judge makes the determination, and then that's an appealable issue, where would the appeal go? Would it go to the appellate division or to the appeals court?
I believe it would go to the appeals court. And this is an issue with respect to the second argument the Commonwealth makes as to specifically whether or not this is a situation that was necessarily brought, say, under a Rule 30A motion or one that should have been brought on direct appeal. I think, and this is one of the arguments that the Commonwealth put forward, that the additional argument was that potentially this should have been a 211-3 petition. I would say respectfully, this being part of being directly a direct consequence of either a guilty determination, be it a plea or a conviction, where there is not immediate confinement, it is one that is properly held on direct appeal. It is a matter that the individual here, unlike in 211-3, which is for extraordinary relief in circumstances where there is no other avenue for relief, I think the Hines case demonstrates that here direct appeal is indeed an avenue for the juvenile here, and I think that properly it should be before the appeals court and then work its way through the system as it has here. Specifically, this is not the hearing under subsection F is not a collateral matter. These are the cases that are discussed in the brief, such as Frere and Quisp, Rodriguez, where collateral has been defined in those cases as a matter that takes place not before this particular judge. I think the court, the appeals court in Schindel does a good job of explaining that, indeed, even in the sex offender context, something is collateral only when it's decided in a different forum by a different fact finder or a different judge. If this was a matter that was before the Sex Offender Registry Board, that would make it collateral. If it was before a federal immigration court, that would be collateral. But here, Section F requires the judge to make this decision, and therefore, because it's in this court, it is not a collateral.
Well, isn't it a reasonable inference that the judge did, in fact, comply with the statute and consider the circumstances of the offense in conjunction with the offender's criminal history? The judge said that he understood that he had the authority to waive finding the person a sex offender, but he was not going to do that in this case because he thought, based on the circumstances of the case, and can't we infer also the circumstances of the offender's criminal history, because the judge was very well informed of the entire proceeding, that the judge did comply with the statute?
I would say the first thing that I would say, for Your Honor, is that this particular section has been noted by the court in the Doe 3 case to be an important safeguard in terms of constitutionality for the entire statute. with that in mind and keeping that in context, it is important for a judge to comply with all elements. I could say here the judge...
Isn't the answer to Justice Ireland's question that the court is not supposed to determine whether whether the offender is relieved of registering or not? The legislature's made that determination. What the court is supposed to determine is whether the circumstances of the offense, in conjunction with his history, indicate he doesn't pose a risk of reoffense, and he never made such a finding.
That is correct,
and
Your Honor.
that's his function. His function is to make a finding.
That is the sole function. Now, subsection F suffers perhaps from some ambiguities. It doesn't lay out, say, burdens of proof. It doesn't make any other directions except for Justice Cowan's point that it is one simple finding, and in this case, that was not met.
Well, what I'm saying is, isn't it implicit that the judge may not have used the magic words, but the statute says if the court so determines, the court shall relieve such sex offender of the obligation to register. And since the judge said, I'm not going to do that, can't we infer that
I don't believe so, Your Honor. I think that what we need to do is, this is a very short hearing. This is a hearing that only goes over about 4 or 5 pages of a transcript. It starts, I think, from beginning to end, there are hints of the problems and the ambiguities in the statute. In the beginning, it starts with the judge asking, is there a motion pending? And indeed, the Commonwealth continues that, saying that this is the juvenile's motion to waive registration.
Well, there's no question the judge knew what the circumstances of the offense were.
Correct. He had just sat in a jury waive.
It's involved a 6-year-old victim.
Correct. And this is something that certainly he had sat there, but the standard, which is the only thing that we have to go by in this case, as Justice Cowan stated, is not something that was actually found here in this case. Instead, he just said, based upon, I choose on the facts of this case not to do so. This was not something that actually followed the exact standard. So, the point that we would bring is that no, indeed, this did violate the juvenile's due process rights because the judge specifically did not even meet that standard, and it is the only thing that we really have to go on from subsection F's language is that we have the standard.
What were the judge's precise words?
He was, I know under the statute that I have the authority to relieve him from his obligation to register as a sex offender, but I choose on the facts of this case not to do so.
See, the problem that I see is his choice of, not to make a pun, but his choice of words, because he says, I choose on the facts of this case not to do so. He doesn't have a choice. The legislature has made the choice whether to relieve him or not. And he's got to make he doesn't have any choice. All he's got to do under the statute is make the findings, as I see it.
Correct.
Well, are you suggesting that the judge did not know what the offender's criminal history was?
There actually, to my knowledge, I don't think there's much of a reference to that. I think he goes through the sentencing process. So I don't know on the record if it's clear if he knows what the offender's history is. That's just off the top of my head. I don't recall if that was a previous issue. Now, I would think that in terms of common practice, it is likely during the sentencing process that the judge would have come into contact with that information.
So precisely what is wrong with what the judge did and said? What is wrong with it?
What is wrong is that I think that, first of all, there is the possibility here, distinct possibility from the first words out of the judge's mouth, that he has an incorrect understanding of what the burden of proof is here, placing that upon the defendant, whereas the statute clearly does not do that in comparison to, say, the lifetime community parole statute, as discussed in the Langgill case.
Well, the statute says that the judge has to determine whether the circumstances of the offense or the offender's criminal history indicate that the defendant does not pose a risk of reoffense. Now, doesn't the use of the word not suggest that it's the defendant's burden? I mean, how would the Commonwealth prove that the defendant is not a risk?
I think that this is perhaps one of the problems with the statute. And I think
but what I'm suggesting is it's not a problem. The word not means that it's the defendant's burden.
I think I would respectfully disagree. I think it is ambiguous, and that's in comparison. The best I think comparator we have is the lifetime community parole statute, which says specifically puts that burden expressly on the defendant.
Well, let's assume for a minute it's your burden, the defendant's burden. Then what is wrong with that, keeping that assumption in mind, with what the judge said? If, as Judge Ireland points out, he obviously knew all the circumstances of this crime, and we can infer he was aware of the defendant's criminal history. I think there
are two main potential problems. The first one comes, as Justice Cowan noted, that it is the standard that was supposed to be applied here was not one that was expressly applied. In fact, it was on the facts of the case I choose not to do so.
And what's the standard?
The standard is specifically whether the circumstances of the offense, in conjunction with the offender's criminal history,
Yeah.
indicate that the sex offender does not pose a risk of reoffense or a danger to the public. I think that one of the other issues...
Bring over some semantics that make no difference here.
I-
The judge's finding equates with that standard.
I would respectfully disagree. I think that it is a slight distinction, but an important one in terms of...
Could you
this-
just say it again to me slowly? Because I'm with you with, I mean, I've got 178 EF in front of me, and you are correct that what he is supposed to do is to look at the offense, the circumstances of the offense, and I have him here looking on the facts of this case. That's the circumstances of the offense, isn't it?
I would think so, yes.
And
Your Honor.
then we've got, in conjunction with the offender's criminal history, and I think just your answer to Justice Island was that this judge was familiar with the offender's criminal history, correct?
That is that would be a guess or an estimate. I think that through the sentencing process that is possible. I don't think there's anything that comes up in this hearing that specifically relates to that second part of the standard.
Okay, so you're saying because he didn't look at this offender's criminal history, that's the problem?
I think that is part of the problem, and I think that there are also, besides just what the judge did, I think there is also the possibility that there is the distinct possibility that there is some confusion over the specific burden of proof in the case, with the suggestion that it is indeed the defendant's motion, that the defendant has that burden of proof, which I would contend in comparison to the lifetime community parole statute that he does not. Also, the other additional argument that we make is that in this very short hearing, the Commonwealth at one point improperly refers to prior bad acts of the juvenile, uncharged bad acts, unconvicted bad acts, relating to the same sort of underlying offense. In terms of the facts, when the judge makes his determination upon the facts of this case, that doesn't, from that, we don't know specifically whether or not the judge is saying the underlying offense or if he's talking about the potential prior bad acts.
Community lifetime probation or parole, whatever it's called, does that actually articulate who has the burden?
It does, and it actually specifically places that on the defendant.
Okay.
And conversely, that is the same sort of thing that under 178E subsection E, it requires the Commonwealth to file a motion. Now under F, there is no placing of the burden. So I would say under cases like Lupo, Commonwealth versus Lupo, and the other statutory interpretation cases, that ambiguity has to be strictly construed against the Commonwealth in the defendant's favor.
Well, if the Commonwealth had presented a witness to give testimony about prior bad acts, would you be making this argument?
At that point, I think there would be. It certainly would have depended on whether or not the defendant counsel had actually made some challenges.
My question
objections.
is, does the statute contemplate the taking of evidence?
I think that
Could you have brought an expert in to say that my client does not pose a risk of reoffending?
I think so. I think so, Your Honor. I think that is something that defendants perhaps in future cases should certainly look at doing.
Maybe not you, but whoever represented this young man didn't do it. So
Correct.
Now, hasn't even if the Commonwealth has the burden, haven't they met it simply by showing the circumstances of the crime and his prior criminal history?
I would say not. In this particular case, it is possible if this were remanded for a new hearing, that I'm not saying that it's not possible that would be met if all of the due process procedural safeguards were followed. In this case, they were not followed, and that causes. And one of the
That's assuming we agree with you that all these other due process things of evidentiary hearing and all that stuff, written decision, so forth, are required.
Yes.
Were there any objections made to any of these points, or were there any requests that the judge file written findings? Were any of those things done?
They were not. And
So none of these issues was preserved?
Actually, I would respectfully disagree, Your Honor, and this is something that's brought up in the Commonwealth's brief. This is not a matter that is one that is brought under, say, 30A, or is one that is a situation where they're raising substantive issues or substantive challenges to the statute. Instead, these are simply unpreserved errors, unobjected to errors in terms of the process.
Counsel didn't ask for an evidentiary hearing.
He did not.
Didn't present an offer of proof as to any expert or
He did not.
Didn't present an offer as to any other evidence he might offer.
He did not.
Well, then
It's a question of substantial risk of miscarriage of justice based upon the articulated errors as laid forth in the brief and here at argument.
Now,
It is
is
not an
this-
issue of waiver, though.
Is this issue of this particular statute, I know it takes place in conjunction with a juvenile case or a criminal case, but does the Sixth Amendment really even apply to this particular issue? Is it part of the conviction?
I think it does, Your Honor. I think that this is a direct consequence, a direct extension of the underlying criminal matter. It's something that's required by the statute. There is no break there's only a 14-day period of time. It's before the same court, before the same parties. This is not something that is a sort of an ancillary or collateral matter.
Now,
I think that it's a
I agree
natural
with you.
extension of the process.
This would be a horse of a different color if defense counsel had tendered, say, an offer of proof from an expert, and the judge says, I'm not going to bother with that.
Yes,
you
I
might have a due process problem then. But on this record, I don't see anything.
I mean,
I know you argue to the contrary.
yes.
Okay. Thank you.
Thank you.
Thank you, Mr. Crouch. Ms. McKenna?
Good morning. If it please the Court, Gail McKenna, Assistant District Attorney for the Commonwealth. To begin with, we're here on the appeal from an adjudication of delinquency, but here we are talking all about the sex offender registry and a collateral portion of what happened after the adjudication of delinquency was complete, which is what forms the basis for my first argument, which is that the Court does not have jurisdiction to hear this case.
Well, let me ask you, Ms. McKenna, are you suggesting that a decision of a judge of the juvenile court is then to be reviewed by an administrative agency, the Sex Offender Registry Board?
No, what I'm saying is that the next step is that the juvenile goes to the Sex Offender Registry Board, and the very first thing that happens is that entire process takes place all over again.
But then there's no appeal of the...
That's correct, Your Honor.
Ms. McKenna, I understand why, why that might be the case, but where the statute gives the judge, in essence, some discretion.
Correct.
I don't know of too many, I mean, you call it collateral. I don't know of too many proceedings where a ruling of a judge, can't be or should not be reviewed here. In other words, let's assume that the judge makes a an appellate court makes a determination that the judge in this case committed an error of law, such as one of the bases of the claims here, that he should have had an evidentiary hearing.
Well, Your Honor, first and foremost, the case has to be properly before the court.
Well,
And
but what
this
I'm saying
case-
is that
Well, Your Honor-
much of what the juvenile is claiming here really might have nothing to do. Just take that
Sure,
single point.
but if it has nothing to do with his criminal conviction, and that's the appeal before the court,
No, it's not that it has nothing to do with the criminal conviction. It has to do with a proceeding before a judge in a juvenile court that the legislature has authorized. There is a claim. Let's
Right.
assume there's a
So
claim.
then the next question is, what's his route of appeal?
Yes, and the claim is.
And he has none.
No, the claim is that the juvenile here, that the way in which the judge conducted the proceedings
Right.
violated his constitutional rights. I'm limiting it to that question for purposes of asking you the question.
Right.
That is not a question that can be decided by any administrative agency. It also can't be the case that if a judge acts in a way against any person in the Commonwealth that the person says violates some fundamental rights, either violates the statute,
Well, then
violates
that litigant still has an obligation to properly bring his case before the court. One way he could do that is through this court's 211(3) power.
That's possible, but it
Right.
can't be that there can be no judicial review. Do you agree
Well,
with me?
I would disagree, Your Honor, and it's always uncomfortable to come before a court and say you have no jurisdiction, you can't review a case that
It's
the
not
court
the
may
case.
be.
There's a claim of improper procedure by the judge in the judicial branch.
Well, Your Honor, not every wrong has a right. This one doesn't have a right. The defendant doesn't have a right to be here making this claim before the court in this manner.
Would this same claim apply to an adult offender as well?
Yes, Your Honor.
So if we decide that he's got this right, then all decisions by judges to not waive or make them register are going to be appealable.
Along with the criminal case.
No,
And
but wait a minute.
essentially
This
what
is-
the
this is-
defendant
this is
is
a-
asking is for this court to overrule all of its jurisprudence that says that the judgment in the criminal case is the sentence is the punishment, and therefore somehow now something having to do with the sex offender registry is now punishment. The court has said otherwise. The judgment in the criminal case is the sentence that's imposed. That's what's appealed from. That's the judgment that comes before the court in a criminal case
Ms.
or in
McKenna?
an adjudication of delinquency.
Is there any legislative history that helps us understand what they contemplated when they wrote this legislation, as far as whether there was a route of appeal, any information that helps us understand what the legislature was thinking about in terms of whether the juvenile judge has the final word here?
Well, I think the thing that's most telling is where in the statutory scheme this fits, and it's right in the statutory scheme with everything else having to do with the sex offender registry. There's nothing in here that is in the juvenile delinquency statute. There's nothing here that's in the criminal penalty statutes.
Doesn't it only apply?
It's completely ensconced where it should be in all of the due process protections and procedures that adhere to an individual who has to go before the Sex Offender Registry Board. And the greatest protection for an individual in this situation is that whatever this judge has done will be immediately de novo reviewed by the Sex Offender Registry Board, and he will have all the rights that this court has approved as meeting due process under the Sex Offender Registry Board
So
procedures.
if a judge determines that the defendant is not, does not pose a risk, the legislation, I take it, takes effect, and he is relieved of the obligation to respond or to report.
Right.
Does the judge's decision then get reviewed by an administrative agency?
No, Your Honor, and that's
The
one of the
Commonwealth
problems.
appeal that?
211.3 would be the Commonwealth's only recourse.
But then
Because
you're saying you could come up here all the time, anytime you were dissatisfied?
Well, that would be up to the single justice at 211.3, but we would have no recourse, and if the judge
Why
had
can't it go either to the appeals court or to the appellate division, which is the question that I asked in the beginning?
Well, the appellate division only of the appellate division of the district court.
Well, no, I guess it can't go to the appellate division of the district court because this is a juvenile court.
Right, and the
so
appellate
it would
division of
be
the Superior Court reviews only Superior Court sentences.
So it would go to the appeals court.
But there's no route of appeal that takes it. The statute doesn't encompass it in any way. It's just something that the legislature came up with as an attempt to give
So you're saying
another due process protection to people who may have to register as sex offenders.
Am I correct in understanding you that the Commonwealth could do a 211.3 or the defendant could do a 211.3 or only the Commonwealth could do a 211.3?
Well, I'm not suggesting either, Your Honor. I think we have to wait until the case comes along and see what happens.
But
the
you
problem.
said if the Commonwealth disagrees with the ruling, you said it has 211.3, correct?
No, what I'm saying is if the Commonwealth believes that they can show the judge abused their discretion, which is the standard that would apply here, not whether that there's a substantial risk of miscarriage of justice, and we all know that that's an onerous standard.
I understand, but let's assume you all agree on the standard, so it's an abuse of discretion. Are you saying the
Or an error
Commonwealth
of
can
law.
have a 211.3? Does that mean that the defendant can have a 211.3?
No, not necessarily,
But you
because
can
the
try.
defendant.
You would have the right to bring it. The single justice may say no, but you'd have
Right.
the right to bring it.
Well, and the example that comes to mind for me is if the defendant were to appear in front of a judge who said, for example, I don't care what this statute says, I think everyone should register. Well, I would say that's an error of law and an abuse of discretion, and that they should take
But
their
if the judge
211.3
makes
right.
the right, uses the right noises, as you contend he did in this case, the defendant wouldn't, according to your argument, couldn't use 211.3 because his remedy is with SORB.
Absolutely, yes.
May I just ask you a question, and it may just turn on the word convicted. Is it because, I mean, essentially what the statute says is a sex offender has been convicted of a sex offense, and then you get the or adjudicated as a juvenile, and then you go
Yes.
down to, and the legislature says to a judge, you can relieve of the obligation to register, right? And then the legislature says, but you can't relieve of the obligation to register in some very serious cases, and they
Correct.
very closely defined, correct? They really go
Yes.
to, I think, the heart of the sexual. Is it because the legislature has used the word convicted at that point as opposed to adjudicated that we even hear on this case? Because the
Yes.
fact, is that the only reason?
Yes, and my brother had referenced that at the appeals court, I had argued that juveniles fell within those narrow exceptions too.
I know that, but
And I withdrew that argument after speaking to the Sex Offender Registry Board. They are the administrator of the statute, and in deference to their interpretation of the statute, I did withdraw that argument.
would it be
Juveniles,
No, I understand the whole, and it may be
right,
that
we
they are
treat them
correct,
differently
but-
for
but
good
would it-
reason.
Would it not be at least a reasonable argument, Ms. McKenna, to say, when you are looking at the circumstances of the offense, never mind in conjunction with anything else, here you are really looking at circumstances that, other than the fact that of the use of the word conviction, are really precisely what the legislature has most expressed concern about, namely a very young child. The victim is a very young child with a very violent series of acts, correct?
I'm not understanding your question, Your Honor. I think what the legislature said here is what the legislature said, that for anyone who was coming within the statute here, what they wanted was for the judge to look at the circumstances of the offense.
Yes, but the legislature has, what I'm saying to you is that the legislature has indicated that certain circumstances, when you're dealing with adults who are convicted,
Right.
are so bad on their face that
Right.
you can never consider those.
Right, we're going to
Here-
presume they register.
Right. Here, the judge had that set of facts, it seems to me, correct, would clearly fall within the convicted of a sex offense involving a child or a sexually.
Right.
And the judge, recognizing that he retains his discretion because it's a conviction, not an adjudication, could well have said, look, this is precisely the set of circumstances that I'm not going to relieve. I mean, isn't that...
Well, I think what we have to do here is presume that the judge acted correctly under the law. There is a presumption of correctness. We have to presume that the judge instructed himself correctly because that is the law. I do want to add that there was no prior criminal history with this particular offender, so all we were looking at were the circumstances of the offense. It was clear to the judge that no motion was filed because this was part of the statute. It was self-executing. It came before the judge. He acknowledged that he was working under the statute before he made his ruling, and he said, based on the facts of the offense.
But may I ask you this?
Sure.
Why couldn't we just say that this was an offense which involved a conviction of a sex offense involving a child?
That's
End of story.
It's the
wasn't a
word
conviction.
conviction rather than adjudication
But my-
of delinquency.
I was trying to make that point, Ms. McKenna, by saying the judge could surely look, not to say he doesn't have discretion, but this is a set of circumstances which isn't even at the margins, correct?
I would agree with Your Honor.
No,
I would agree with you.
on your broader argument that all of them have to go to SORB, is there something in the SORB regulations that says they examine these things de novo?
Yes, Your Honor, there is.
So if he goes over to SORB, SORB could say, well, we see the judge decided not to relieve you of this burden, but we'll look at this again.
Well, I don't think they're allowed to take into account what the judge, what the judge did or didn't do is irrelevant. They start de novo.
Does the regulations say that?
Yes, they do, Your Honor, and the regulations set out what they're to take into account when they're making their determination whether or not, and it's essentially the same, making their determination whether or not he has to register. So that takes place immediately thereafter. Essentially, this is another bite at the apple before the judge.
Ms. McKenna? Maybe I asked you this, but I don't remember. If the judge were to find that the particular juvenile is relieved from registering, can the Commonwealth try to do something before the board, to bring it back before the board?
No, Your Honor. It's a final decision. And as I said earlier, the only recourse the Commonwealth would possibly have
To 11-3.
right, under the onerous burden of whether the judge abused their discretion. But again, the court should never reach any of these underlying issues because there is no jurisdiction in the first place. And as interesting as all of these issues are,
We should, because we've got to tell them how to do this, these other issues.
well,
Who's got the
other-
burden and so forth.
Well, I understand that, Your Honor, but the other problem here is that these issues are waived. They were never brought before the judge in the first place. So the judge never had first crack at dealing with any of these issues. There's no reason to believe that the judge did anything wrong, that he applied a wrong burden of proof, that,
Well, I know that, but it would be helpful for the future for other judges to know what they're supposed to do.
I would respectfully say
I mean,
that the
suppose
court-
we say there got to be an evidentiary hearing.
well, under
Better
the
say it
statute,
today than wait for another case and reverse it.
well, there's just been a large evidentiary hearing called the trial, Your Honor, with all due respect, and I would say that
Well, I
that
know it,
should
but I'm
suffice.
addressing just one of his arguments, on how these things should be conducted and who's got the burden of proof, all that kind of stuff. It
Well,
seems to me to
respectfully,
be
Your
helpful.
Honor, I think it would be more helpful if the case came up on a full record, say under a 211-3 petition,
Yeah.
under a full record with
Well, we're
all these
arguing about two
issues
different
fully
things.
developed.
I'm saying to you, on this record, at least, you may very well prevail if we even get there on the way this was handled, because his lawyer didn't do any of the things that he's now asking for. In the future, however, some lawyer is, and maybe we should clear this up now on what has to be done or not done.
No, and my only point, Your Honor, not to beat a dead horse, is just that it should happen on a full record. And I think that it would be more appropriate under a 211-3 record where all of these issues are preserved below and a trial judge has had an opportunity to make the right findings and to preserve his issues.
Why do we have all these trouble with juvenile courts down in your county? We just got done with Tobin Kearns and the ruminations about what
Miss-
the instruction ought to be.
It's me, Your Honor. I
Ms.
love to
McKenna,
come up here.
Can I just revisit that, the colloquy you've just had with Justice Glaney? It seems to me that one of the difficulties here is, notwithstanding the ultimate outcome in the appeals court, and I recognize that it's a 128, but the appeals court went on to make certain statements. It is a 128,
Correct.
but as you and I know, with computers, if you're a trial judge in the juvenile court and you've got an appeals court panel saying
Here's how you do it.
the judge was not required to do this, was not required, and then trial judges go ahead and don't make findings, and then it comes up here, and we say, oh, no, you have to make findings, and we don't have any findings. I mean, that seems to me to be one of the problems.
But
I mean,
frankly, Your Honor, they're not constitutionally required to make findings, and usually the
Yeah, but
findings
that's on
are
the
pretty
merits.
clear.
that's on the merits.
And in a simple case like this, I think the findings are readily apparent.
I understand, but in any case, I mean, you see the problem.
Thank you all
It
for your
goes
kind
around.
attention.
It goes around. The 128 goes
They
around.
certainly do.
Which is unfortunate because they aren't precedent, and I know
Well, in
that.
fact, as you may know, there's a huge constitutional argument about that in the federal court, so it's not entirely clear that we can simply say, well, they're not precedent. I mean, there's a problem there.
I understand that.
Well, thank you for helping us figure out.
Well, thank you all for your kind attention
Partially,
today.
anyway.